Ready? Start. The true taste, according to the court, is whether the effect of the impugned action is to take away or abridge fundamental rights. It was stated that the word direct would go to the quality or character of the effect and not the subject matter, and the restriction sought to be imposed by the impugned newsprint policy was in substance a newspaper control, that is, to control the number of pages or circulation of dailies or newspapers, and such restrictions were clearly outside the ambit of Article 19(2) of the Constitution, and therefore were in abridgment of the right of freedom of a speech and expression guaranteed under Article 19(1)(a). And it added, the newsprint control policy is found to be newspaper control order in the guise of framing an import control policy for newsprint. This court in the bank nationalization case laid down two tests. First, it is not the object of the authority making the law impairing the right of the citizen, nor the form of action that determines the invasion of the right. Secondly, it is the effect of the law and the action upon the right which attracts the jurisdiction of the court to grant relief. The direct operation of the act upon the rights forms that real test. No law or action would state in words that rights of freedom of a speech and expression are bridged or taken away. That is why courts have to protect and guard fundamental rights by considering the scope and provisions of the Act and its effect upon the fundamental rights. We have only to substitute the word execute for the word law, and the result is obvious. Here, the impugned notices of re-entry upon forfeiture of lease and of the threatened demolition of the express buildings are intended and meant to silence the voice of the Indian Express. It must logically follow that the impugned notices constitute a direct and immediate threat to the freedom of the press and are thus violative of Article 19(1)(a) read with Article 14 of the Constitution. It must accordingly be held that these petitions under Article 32 of the Constitution are maintainable. This decision in Express Newspapers Private Limited was rendered by a three-judge bench of the Supreme Court. With the said decision, the Supreme Court held that the action taken by the then government against express newspapers was malified and politically motivated. The principal point in controversy between the parties is whether the notice of re-entry upon forfeiture of lease issued by the engineer officer, Land and Development Office, dated March 10, 1980, purporting to be on behalf of the leisure, that is the Union of India, Ministry of Works and Housing, and that of March 1, 1980, issued by the Zonal Engineer, City Zone Municipal Corporation, Delhi, were wholly malafide and politically motivated. It is a shared reflection on the state of affairs brought about during the period of emergency which brought into existence a totalitarian trend in administration, and I do not wish to aggravate any of its features by unnecessary allusions. In the process, the country witnessed misuse of mass media totally inconceivable and unheard of in a democratic form of government by ruthless suppression of the press by exercise of pre-censorship powers, enactment of a set of draconian laws which reduced freedom of the press to a tout. The petitioners have pleaded the facts with sufficient degree of particularity, tending to show that the impugned notices were wholly malafide and politically motivated. Malafide because the impugned notice of re-entry upon forfeiture of lease dated March 10, 1980, issued by the Engineer Officer, Land and Development Office under Clause 5 of the Indenture of Lease, alleged breach of clauses 214 and 25, which in fact were never committed, and the notice by the zonal engineer buildings, City Zone Municipal Corporation, for demolition of new express building where the printing press is installed under sections 343 and 344 of the Delhi Municipal Corporation Act were really intended and meant to bring about the stoppage of the publication of Indian Express, which has throughout been critical of the government in power whenever it went wrong on a matter of policy or in principle. Also mollified because they constitute misuse of powers in bad faith, use of power for a purpose other than the one for which the power is conferred is mollified use of power. Same is the position when an order is made for a purpose other than that which finds place in the order. In the facts and circumstances, I am constrained to hold that the impugned notices dated March 1, 1980 and March 10, 1980 were not issued bona fide in the ordinary course of official business for implementation of the law or for securing justice, but were actuated with an ulterior and extraneous purpose, and thus were wholly mollified and politically